But without further ado, let's kind of jump right in, John. Let's talk about this case. This is Shanique Everett. It's an existing client, an existing case we have where there's kind of two components to her case. She's got the underlying lawsuit we filed, and then this appeal that I want to talk about with everyone. For a little backstory, our client was shot and injured in a parking lot outside of an adult entertainment club a couple of years back. And we filed a lawsuit for personal injury in the local state court. And the insurance company, AIX Specialty Insurance Company, who presumptively had a duty to defend and indemnify that claim, at some point filed an action for declaratory judgment in federal court. And it wound up in the Middle District of Florida. And so we kind of had to put the underlying case on hold for a bit while we defended, interestingly, argued for coverage, basically, the coverage should stand in that case. And so what we decided to do was tackle the argument presented by the insurance company head on in a way that I think I'm proud to speak for both of us that no one else, it seems, in the country had yet done. So there's a standard policy exclusion in a lot of these contracts for firearms. And it reads basically something to the effect of if a person is injured by a firearm or multiple firearms, then it's not covered. So it had been invoked, and we decided we were going to challenge it because in this particular context, the firearm exclusion read firearms, not firearm. And we made the technical argument that if someone shot by a single bullet, that necessarily means they're by a single firearm. And if the exclusion, the firearms exclusion only uses the plural form, not singular, then it doesn't apply. So March 30th, we got the ruling, and I'm excited to announce that the panel, all three unanimously affirmed the Middle District, who had previously ruled in our favor. You can see here that our argument was that she was shot by a single projectile, and that's what we pled in the complaint below. And in the federal deck action, that's the record that the court rules on. So AIX tried to invoke this firearm exclusion, claiming that, there's no coverage for injury, death, claims, or actions occasioned directly or indirectly, or as an incident to the discharge of firearms, plural, by person or persons on or about the injured premises. And so what we did is, as I said, we showed the district court, hey, look, this insurance company knows how to use singular versus plural because they did it in the same clause. They did person or persons. But when they talked about firearms, they only used the plural, not the singular. And so as a result of that, it shouldn't apply to our case. And I'm happy to report that, we below on the trial court level, both sides moved for cross summary judgment. We won. And on appeal, the panel affirmed. So that means for all intents and purposes at this point, there's going to be a duty to defend. I think the duty to indemnify wasn't expressly ruled on, but I think it's closely related. So I don't expect anything different. And it's a big win for us because, as we could tell when we argued it, there wasn't any pre-existing precedent on this particular technical argument. And
well, I think you're kind of underselling it. So Jordan's our linguistic ninja, right? Like he's the, obviously before we have now the director of appellate practice, but he was the one handling all the appeals and what. There's actually two opinions where this particular provision has been upheld, right? And so when Jordan said, look, this argument wasn't presented in those cases, right? And he was kind of, it was laughed at, like, oh yeah, good luck. That's never going to happen. We've already won this issue. That we have other district court opinions. And it's exactly what the district court ruled on. It's like, look, you drafted this policy. You put the language in there, and obviously it's construed against them. And because Jordan said, look, in other contexts, they used person or persons, here they just said firearms. And we said she didn't get shot by or injured by firearms. It was just a single firearm. And the district court, I don't want to say bought it, but the district court accepted that reasoning, that well-reasoned analysis, and he calls it a technical argument. I think it's a great argument of why that policy is invalid. So really, any specialty AIX insurance policy where there's a firearm exclusion, look at the policy language, right? If your client was shot once by a single firearm, and that's how you plead it, and they don't have firearm or firearms, there's going to be coverage, right? So, and even some of the cases where you may have thought there wasn't coverage. So that's kind of in these negligent security contexts to have something that's not excluded and to make a claim now, because they were beating their chest since day one. We're out. We're going to be out, and now they're not. And so that
right. And I mean, what a difference for our client. I mean, the difference a ruling can make going from, and she's seriously injured no matter what happened. She's been shot. I mean, it's a horrific experience. But whether or not there's coverage is kind of outcome determinative in terms of the likelihood of her recovery, especially against a defendant like this. And so I'm proud of the win. It was a collective effort. And I don't mind being laughed at by, people who disagree with my positions, even if they're my friends on the other side. At the end of the day, if I believe in a position, I think we have a legitimate chance to win. I'm going to argue it. And I'm proud that the federal courts agreed. I will say this, even though we're not giving legal advice and we're not starting attorney-client relationships with anyone, for the other practitioners out there, this policy exclusion, the firearms exclusion, I think it's an ISO standard. So it's likely to be within some other policies, even if the insurer is not AIX. So, look, what does this tell you? I think this is a specific example of a broader point, which is, as a practitioner, don't take anything for granted. Don't just accept deck pages, get the full policy, read it closely, and especially where there's a coverage defense, don't just concede it.